I'm Anthony Kovic, and you're watching LeaderCast Business Brief. Today I'm here at downtown Brooksville with Tom Hogan of the Hogan Law Firm in their Brooksville, on location Brooksville offices. Tom, thank you for having me here at your offices. We're here in the boardroom to discuss basically basic law understandings. So the first thing we're going to discuss is contracts. Tell us about the importance of contracts in the legal formula of why they're important.
First of all, let me thank you, Anthony, for coming back to our conference room. It's always a pleasure to see you.
Thank you.
Contracts are a basic function of the way that we agree to do business together, for example. And the right to contract is guaranteed under the Constitution. There are some basic things that I recommend to clients before they enter into any kind of major transaction, and that is to have a contract. And the first thing they need to do, step number one, is to identify and solidify in their own minds what their goals are, what do they want to accomplish. And the best way that I suggest that they do that is to seek out a business lawyer. Now, there are lots of lawyers, but in today's world, it's unrealistic to think that every lawyer can keep track and keep current of every area of law. So you need to find a lawyer that practices business law. And then you need to go to that lawyer and you need to let that lawyer help you define what your goals are. And then you want to craft the contract around your goals. And there are some basic things that you want to have in a contract, and you have to have what's called offer and consideration. A lot of times people come to me with handwritten or self-typed agreements that skip over some basic steps. That means that the contract's probably not going to be enforceable. If you don't have an exchange of consideration, normally money, then a court is or may not find your contract to be enforceable. You need to have a venue and jurisdiction clause, in my opinion. You want to define what court or what venue you want to be in the case that your contract is disputed. You don't want to find yourself in Minnesota under Minnesota law, trying to find a Minnesota lawyer to defend you in a place that's far, far away.
Now that works if one of the companies or organizations is in that jurisdiction. Is that correct, or is it if two people are putting together a contract in Brooksville or Hernando County? Is that automatically adjudicated in Hernando, or can that be changed?
Well, normally, if both parties are in Hernando County, then the dispute will be resolved in Hernando County. If the dispute involves real property, it's called NREM, REM, then the dispute will be resolved where the property lies. But a lot of times, I have had clients that have come to me with contracts that they've already signed that is a major venture for that client, and they've entered into some sort of partnership with an entity that is out of state. And at the time, of course, when you enter into an agreement, everything's going along fine, very smoothly, and you're not worried, and you skip right over that paragraph that says venue jurisdiction in Georgia or Minnesota or Louisiana. I've been all over the place because of venue and jurisdiction clauses. And sometimes if you're dealing with a major multinational company, you may not have any choice. So then you have to make a business decision. Do I need this relationship with this entity so bad that that it's worth it to me to risk having to go to Minnesota to deal with them if the contract doesn't work out? But I've also found on many occasions, recently we have a local client that wanted to do business with a multinational company. I almost said the name, but I probably shouldn't. But a big company that you see on advertising on TV routinely. And we held our ground to have venue and jurisdiction here in Hernando County, and they eventually agreed to it. So you never know, but that's an important part of the contract. A
contract, we were kind of talking a little bit earlier before we got the segment started, and one of the discussions was that a particular client happens to have, and we're not going to go into the client, only that you don't actually have a physical paper to be a contract. A contract could be verbal or just a handshake on specific ideas. But obviously now it's he said, she said, etc. So tell us about verbal style contracts and how enforceable are they?
Verbal contracts, Anthony, are enforceable. But unfortunately they do boil down to he said, she said. Well, what courts will do in those circumstances is they will look at what's called course of dealing. That's recognized under Florida statutes and under the Uniform Commercial Code and under Florida case law, and most states recognize it as well. If you have an oral agreement and you can't agree on what that agreement is, or you can't agree on who breached that agreement, a judge or a court will go back and look over the history of time and will find that, well, normally A delivered the product to B by the 10th of the month,
yes,
and B normally paid A by the 30th of that month. And so once that pattern is established, the court will interpret that as a term of the contract. So even though it's not in writing, you may find yourself bound to an oral agreement.
Now, can a contract be an oral agreement? Let's say in today's world we all have cell phones. If, let's say, two people got together, put on a cell phone on video and said, hey, we have this contract, this is what we're going to do, I'm going to do this, you're going to do that, and it's in video. I send you the file, I have a file. Is that a contract?
Yes, courts can piece together contracts from emails, text, letters, course of dealing. They can take all of those things and put the puzzle together. If you and I were to shake hands on this video and you said, Tom, I'm going to pay you $1 million to be on LeaderCast today.
Oh, yeah. That is not the case, though.
Not the case. But I could argue, soon. I could argue that, that we had an agreement, and I could use the video as evidence of that agreement.
So basically, in a contract, depending on the type of contract, the better the contract and all of its pieces in a document, the less the court has to spend time, money, and etc. The less it's written out, now they have to, the investigative part of putting together that contract and arguing it is where it becomes expensive, because now it could take, instead of looking at this piece of paper, saying, okay, this is what you said, this is what he said, these are the variations, and the judge can look at that and render a verdict, where otherwise there has to be an investigation, and that's where it can become expensive, correct?
That's where it can become expensive, and that's where you can, where a judge may come up with some answer that you don't like. So if the terms of the agreement are in writing, then the court, you, and the other side are bound by what's in writing, unless it's unlawful or for some other reason unenforceable. But if it's not in writing, for example, if there's no mention of venue or jurisdiction, a court will decide where the proper venue and jurisdiction is. So if it's not in writing, then the court can look for other evidence as to what the agreement was. So it's best to get at least the most important and basic terms agreed to in writing, and hopefully your business lawyer will make sure that you capture your goals in that agreement.
So that's the key part, is it's a lot less expensive to call your firm and say, hey, Tom, you're an expert in contract law. I need a contract. This is what it is. I mean, how expensive can it be to put together a few pieces of paper? Is that compared to having to litigate it?
Well, as compared to having to litigate it, it's a tiny fraction of what litigation costs. The cost of a contract varies by its complications.
Yeah, I mean, we all know that, but I'm just saying, compared to the outcome of having to litigate it,
right,
it's a lot less expensive to actually just put together your goals, and for you to organize what needs to be done.
It's like the old adage, pay me now, pay me later.
Yes.
And what we like to practice at our firm is what we call preventative law. And if you have a good contract, you're going to prevent litigation. And so we preach that to our up-and-coming attorneys, and we preach that to our clients. Oh, my name is Tom Hogan. I founded the Hogan Law Firm more than 30 years ago. And what we really enjoy doing here is getting to know our clients and trying to help you solve your issues, your problem, your transaction. We enjoy that. We're lucky that we can make a living doing that, but the main source of our satisfaction over the years is the friends that we've made through the practice of law and the people that we've helped. Our main source of business is the referrals from our former clients. So give us a try, give us a call. We can represent you in many areas of law, whether it's family, domestic law, divorce law. We do a lot of transactional law, meaning wills, trust, estates, real estate transactions. We handle civil litigation. We handle employment law, representing employers primarily. One of our attorneys is very well qualified in that area. We represent several governmental entities, so we have experience in that area and can represent you with other governmental entities where we don't have a conflict. So if you'd like to get to know us, if you'd like to see if we're the attorneys for your issue, give us a call at our phone number, 799-8423. We have 2 locations, one in Brooksville, just down the street from the courthouse, 20 South Broad Street, and one in Spring Hill at the corner of Mariner and Spring Hill Drive. Look forward to getting to know you. Thank you.
Now, who should actually implement the contract? When you have 2 people talking about doing something together, does either party can organize the contract and have the other party sign it? Or does it have to be my lawyer send it to your lawyer, that kind of stuff?
It doesn't have to be. I will not represent both sides of a contract. I know a lot of lawyers do that, and there's nothing wrong with it, except that if there's a dispute, then you can't handle the case.
Yeah, so.
And there's also the risk that you may be accused of favoring one side over the other. So, but either side can initiate the writing of a contract. My advice is that if you are going to enter into a business deal, that you go to your lawyer early on and you take control of the situation. You get your goals defined, you get your goals captured on paper in the contract, and then take it to your business associate, and hopefully they can review it and agree to it, and then you can get underway with your business.
And so once it's written, let's say there's a minor adjustment, then it's just a matter of whether or not the 2 parties agree to the adjustments.
Exactly.
And then that is adjusted and then reprinted, correct?
Exactly. When the contract comes back to me as the attorney with several amendments to the contract, adjustments, then it's my job to ask the client, how important is it to you to be paid by the 20th of the month? And if it doesn't matter to you that you're paid quarterly instead of monthly, then let's don't fight over it. If it's crucial to you, then let's stick to our guns. But like any agreement between human beings, there's going to be some give and take, and the client has to make some business decisions as to whether they're going to accept these adjustments, amendments, or not. And it's also up to the client to do most of the due diligence with regard to who are they doing business with. And that's one of the things that we try to help with in the very first meeting that we have with the client. But most of the legwork is usually done by the client. Who are you doing business with? Do they have a good credit history? Have they been in litigation before? Have they breached other agreements? And those kind of things you need to know.
Now, is that something that you guys handle? So if, let's say, somebody showed up and said, hey, these are my goals for dealing with this business associate, etc. I only know this amount about this person based on friends or whatever. Can I do an investigation through you to actually learn more about whether or not this contract is worth even printing it?
We can do that. We can learn almost everything about any company or any individual A to Z from the beginning of time in this day and age. We have a vendor that we do business with that can trace back every single boat a person's owned, car, house, credit references, credit ratings. So, for example, if someone wanted to hire your company to come to a distant city and do a video conference for a week, but they didn't want to pay you until at the end of the conference, and I advised you, I would say, Anthony, you don't really know much about this company. My advice is that you get a down payment, and if they refuse to give you a retainer, then it's a business decision on your part as to whether you want to take that risk or not based on what you can learn about that company. In your investigation, and if we help you with the investigation, if we find out that they haven't paid other professionals like yourself, then
the likelihood is might as well write it off now, right?
Exactly. You write it off now or get paid up front would be our advice. But it's a business decision.
Yeah, that is correct. That's why, some of these bigger companies, depending on the deal, their payment history equals whether or not how the contract's written up. Like, well, we've done business before and you guys never paid on time. So if you want this project now, you got to pay up front or else we're not taking it.
Right.
So anything else about contracts that, the viewer should be aware of that that they should be considering when to do a contract?
Well, every person or business is different. Every business or every person knows what their threshold of pain is. And so if the transaction is of a size that is outside of your normal cost of buying copier cartridges, then you probably want a contract. If your business is of a size that you can afford to write off a loss of, let's say, $50,000 and not blink an eye, then you probably do have a contract, but you may not need one for that particular transaction. So everybody's different. But one of the things, there are several things that are basic to all contracts, and that is due diligence, define your goals, make sure that you know if there's a dispute, make sure you know what law is going to apply. And if you're located in Hernando County, you want to make sure that Florida law is going to govern your contract. You want to make sure, if possible, that if there's a dispute, it's across the street over here at the courthouse and not in Atlanta or Chicago. And I've had litigation in Chicago, and it seems like every time there's a hearing, it's in the dead of winter.
Oh, yeah, of course.
Of course. And you want to make sure that the party that signs the contract for the other side has the authority to bind that company to the agreement. We've had situations where a person has held themselves out to be a vice president, and then we find out later, or the client finds out later when we get the litigation, that that person, in fact, didn't have the authority to bind Company X to the agreement.
Yes, so that's another thing. So does the person have the authority that you're dealing with? He may be the vice president of copy and maintenance.
Exactly.
Company, not the vice president of the transaction related to buying the property.
Right. Now, there are remedies, but, you know, those, we can go into all those another day, but if a person holds himself out as having authority and the company doesn't stop them, then they probably are on the hook. But
Okay, so what about like a simple form? You know, I mean, we see it all the time, you know, when you're buying, you know, a service, a gym's agreement, you know, for $10 a week or a month or whatever, and it's got your name, it's got a bunch of stuff in there. You agree to pay for 6 months or 9 months or 10 months, whatever that is. Is that an official contract once you sign it and you're stuck to it?
it is, and you need to read those contracts. Everyone is, almost everyone is guilty of signing a loan document from a bank or a gym membership, and they will come to us and say, you know, I missed one payment, now I'm being sued, and they've gone ahead and charged the whole year to my credit card.
Yes.
Can they do that? And you read the fine print, and sure enough, it says, if you are 30 days late on a payment, we can
charge you for the full
charge
amount.
The full amount is due when you sign this agreement. We are allowing you to break it down into 12 monthly payments, but if you miss a payment, we can collect what is due the entire 12 months in one claim on your credit card. And so that's the way most promissory notes are written these days with banks. They can call due your entire mortgage if you are late. They can call due your entire membership if you're late at the gym. And you might come in and say to us, you know, the weight machine broke and all of the weights fell on my chest and broke my sternum. I was out of work for 6 months. I'll never be the same. But the contract says, I waive any claim to personal injury. Those are hurdles that your lawyer then has to get over. So the gym probably won't let you join if you don't sign the contract.
Now, let's say you put together, you're going to the gym, and you're looking at the contract, and it has some of those pieces. If I say, you know what, I don't mind joining the gym right now, but you see this line here? No good. I'm not going to accept this.
Mm-hmm.
So if you want me to accept, if you want my credit card right now, you have to accept me crossing out this line. Can I get someone there to initial it and saying, hey, this thing was bypassed? Is that a possibility?
That is a possibility, and even if they won't initial it, if you cross it out and you initial it, it shows that you have not agreed to that term. It's not likely that a big company is going to give in. It's not likely that the guy or gal behind the counter is going to have the authority to amend that form agreement. But if you stick to your guns, you'll be surprised how many times you can get that contract amended, because that gym may have a quota that they want to for members that month. And if you tell them, yes, I'll sign it, but I'm not going to agree to waive my rights if the equipment breaks and falls on me.
Yeah, so any contract out there that is your standard stock contract for anything, and whatever you don't like on it, if you cross it out, whether they accept it or not, you know, as long as it was signed and they have their copy with your cross out on it, let's say it's a carbon copy contract.
Mm-hmm.
So if you cross out and initialize it, that you're not accepting that, on their copy it has the same thing.
Right.
So in litigation, is that something that can be litigated in your behalf because you have, you know, not accepted that clause, that amendment?
Your argument in that case is that I amended the contract, I initialed it, I crossed out that paragraph or that line, and or I changed is to is not, and I initialed it. They refused to initial it, but that's what I agreed to. Now, the other party to the contract is going to say, we never agreed to that amendment.
Once they take your money, they agreed.
Well, then what exactly? Once they take your money, your argument is, hey, they took the money and that was a binding, that made it a binding agreement. They're going to argue there's no meeting of the minds, which is another essential element of a contract. But I would say that if you cross it out and you initial it, you have a pretty good argument.
So we're not talking millions of dollars. Let's say it's, you have a balance of $200. I mean, is corporate really going to come and argue over that if there is for over $200 instead of getting you to pay the $20 a month? I mean, it all depends on the size in some cases. But when you're arguing it with customer service, at least you have something to argue.
What normally happens in a service contract, like a gymnasium membership that is small, if it's less than $1,500, I believe it goes to small claims now, and so you don't have to have an attorney, but you don't have to have an attorney, but the corporation does have to have an attorney.
Exactly.
So is it likely that a corporation is going to retain an attorney to come fight you over $200 or $500 or $50? No.
No, they're going to just put you back on the schedule and...
Or give you a refund or whatever you want. Yeah.
Exactly. So, yeah, because I've had to deal with, whenever, like, you buy, when a company is bought and the contract you have transfers over to the next company, sometimes those companies come up with some really good stuff, and the new company never realized that, what? We're going to do this? They try to fight it, but in the end, you just got to stick to your guns and keep these documents. Now, in the case, when it comes to contract law, let's say I was to scan this document. This is a piece of paper. We had a piece of paper that we had a document. But a document was scanned, and the piece of paper is lost. Is the scanned document still part of the original document? Yes.
A photocopy or a scanned electronic copy in today's world is or can be the contract. It doesn't have to be on paper anymore.
Yeah, because more and more people are scanning their documents. They don't have time to keep boxes of this trash sitting around for decades. And so, in Florida, we all know hurricane season is upon us.
Yes, it is.
And one of the things that, as part of my prepping book is I tell people to scan your documents. Have them all with you on a thumb drive. So this way, if you have to leave town and all your stuff is lost, you could reprint grandma's pictures. You could reprint all your documents. And I just wanted to ask that question, whether or not it still holds up in court as the original document.
It's an excellent question. Your book is excellent on the topic. And yes, it does hold up. And we scan all of our documents here at the law firm. And we have an off-site server that maintains those documents, and we advise our clients to do the same. We don't keep hard copies of documents anymore because, like you said, paper takes up a lot of space, especially if you...
Who can find it, right?
Well,
it's not searchable unless you put a team of people on it.
That's right, and filing is the last thing people want to do. Of old paper used to be... Because I've been doing this for so long, it used to be the paper world, and filing was always a struggle. But now you have a computer that can do the searching for you. It's easier to find.
And with OCR Document Readers, that means they could read the text of the graphic. So if it's a picture of this document, the technology can now read the actual words on the document.
Yes, and it can be... we always have our clients sign in blue ink, so it's distinguishable from the black ink that's the print.
Okay, so blue ink, meaning blue, is slightly off color than black on black.
But it will show up with our technology, it shows up as blue, as a blue signature. So we know that that document was signed. That becomes the original, and they are accepted in court. You can even email them, the documents, to the clerk before the trial, so the clerk has all the documents in place, and then the judge can rule on their admissibility from the bench by looking at his computer that he has on the bench.
So a color scanned photo of your document, meaning it's full color, and your signature is in a separate color, like this is in green.
Yes.
You know, in this case, but anything that was written or a signature in a different color stands out as red, you know, not looking like a copy of a copy or something.
Yes, sir. That's all right.
Very interesting. So that's another tip for you guys, to look at the signature. Use a different color ink.
That's one of the things that we do. Not legally required, but we think that it makes it easier to distinguish the document that was actually signed by the client.
Very good. So as far as documents go, is there anything else that the audience may be needing to know about documents, whether it's, you know, a small transaction or a large transaction, anything on piece of paper that says A, B, C, and D, even if it's small enough for, you know, $200-300, you know, buying and selling a car. You know, not everyone goes and buys a official document.
Right.
As long as it has the basics of the transaction, you know, and two people that live within the vicinity, a simple document is still better than nothing.
Well, my advice has to be, first of all, have an attorney, have a business law attorney that you have a relationship with. It's not going to cost you very much money to have a simple contract like you're talking about reviewed. Know what your goals are before you rush in to a written agreement. Read the contract. So if you are giving up rights, if you are giving up Florida law, for example, and you're agreeing to be governed by Georgia law, at least know it.
Yes.
Don't be surprised by it. So if you sign a document, make sure that you know and understand what you are signing. If you don't understand it, for goodness sakes, go to an attorney and ask them some specific questions, as, you know, what does this mean, venue? What does venue mean? What does jurisdiction mean? And what does this mean, integration clause? What does this, you know, what does it mean, time is of the essence? Yet those things you're going to see in every contract. So if you have a question, go to your attorney and get those questions answered. It's much, much cheaper than going to court.
Well, there you have it, guys. I'm Anthony Kovic, cast here with Tom Hogan of the Hogan Law Firm at their, you know, downtown Brooksville offices. You also have offices in Spring Hill for their convenience, correct?
That is correct. Corner of Mariner and Spring Hill Drive.
Is there a phone number in case anybody is interested in conversations?
352-799-8423. If they want to call Spring Hill directly, it's 686-0334.
Very good. Well, again, I'm Anthony Kovic for LeaderCast.